President Trump has set his sights on the Ivy League giant Harvard, accusing it of tolerating anti-Semitism on campus. Nationwide, Jewish students' dorms have been vandalized with anti-Semitic graffiti. Physical intimidations are up, way up. Students shouting down and blocking Jewish students' access to buildings, and assaults are on the rise. In a now famous exchange in Congress, Harvard's president was asked a yes or no question.
And Dr. Gay, at Harvard, does calling for the genocide of Jews violate Harvard's rules of bullying and harassment, yes or no?
Harvard's president, Dr. Gay, gave a sophisticated shrug.
It can be, depending on the context.
It's a dramatic showdown pitting the federal government against academia, and it raises big questions. Can a president really yank a university's tax benefits over campus hate? And where's the line between enforcing public policy and trampling free speech? This is a deep dive into these questions. We're going to examine the horrors of hate percolating at America's elite colleges as of late, examine how Trump might win this case, and then how he could lose it. Try to stick around so you can get all the angles on this controversy. President Trump's confrontation with Harvard burst into public view with a blunt message on social media. Remember, tax-exempt status is totally contingent on acting in the public interest. In Trump's view, Harvard has failed that public interest standard by not doing enough to protect Jewish students and stamp out anti-Semitism on campus. His charge is that the university's handling of recent anti-Semitic incidents has been so poor that it amounts to institutional misconduct. And he's not just talking, he's already taken action. In April, the Trump administration actually froze over $2 billion in federal funds for Harvard, much of it for scientific and medical research. An even larger $8 billion in funding was threatened unless Harvard met a list of demands, like eliminating DEI programs. Harvard's leadership balked, with Provost and Acting President Alan Garber insisting the school will not negotiate over its independence or its constitutional rights. In response, Trump upped the ante. He directed officials to ask the IRS to review and potentially revoke Harvard's tax-exempt status. To Trump and his supporters, this is about holding elite institutions accountable. Harassment of Jewish students is intolerable, his administration declared as it suspended Harvard's grants. They argue that universities like Harvard have been coddling anti-Jewish bigotry under the guise of free speech, and it's time for a tough crackdown. In fact, some conservatives say, finally, a president is enforcing civil rights at colleges as presidents before him should have done. Trump's allies point to the surge in campus anti-Semitism and ask, why should American taxpayers subsidize universities that turn a blind eye to hate? So what's the history leading up to this showdown? The story begins with troubling incidents of anti-Semitism and anti-Israeli fervor on campuses, especially after the outbreak of the Israeli-Hamas war in October 2023. At Harvard, things came to a head immediately after Hamas's brutal attack on Israel that month. 34 Harvard student organizations signed an open letter proclaiming that they hold the Israeli regime entirely responsible for all unfolding violence following Hamas's massacre of Israeli civilians. In effect, these groups blamed Israel outright for the slaughter of its own people, with barely a mention of Hamas's atrocities. Democratic and Republican lawmakers alike, from Representative Torres to Representative Stefanik, blasted the letter as attempting to justify terrorism. Harvard's Jewish community felt betrayed. Harvard Hillel decried the statement as further hatred and anti-Semitism, condemning how it blamed the victims of a terrorist onslaught. As one Jewish student leader put it, these are the most deadly attacks on the Jewish people since the Holocaust. Blaming us for these attacks is really hurtful. And the Harvard letter was just the first spark in a larger fire. Across the country, other elite institutions were engulfed in a similar controversy. At Columbia University, a professor faced an outcry and petitions for his removal after praising Hamas's attack as awesome, a statement as shocking as it sounds. At Cornell, things turned dangerous. A student was arrested and charged after posting graphic online threats to shoot up a campus dining hall frequented by Jewish students, vowing to kill any Jewish people he saw. His chilling post even threatened to rape and behead Jewish women and babies. A stomach-turning reminder that this isn't about mere political debate, but outright violent anti-Semitism. At MIT, Stanford, and other schools, large protests and incidents of harassment were reported, leaving many Jewish students feeling unsafe. By late 2023 into 2024, the issue of campus anti-Semitism had reached a boiling point. Congress held high-profile hearings, grilling Ivy League presidents, Harvard's Claudine Gray, MIT's Sally Kornbluth, and Penn's Liz McGill. All sat before the House Committee on Education in early December, and it was a PR disaster for the academics. Harvard's president could not unequivocally state that calling for the genocide of a race of people violated Harvard rules.
So the answer is yes, that calling for the genocide of Jews violates Harvard Code of Conduct, correct?
Again, it depends on the context.
It does not depend on the context. The answer is yes, and this is why you should resign. These are unacceptable answers across the board.
To the watching world, that sounded like Harvard's leader was okay with genocidal rhetoric in at least some context. That 90-second exchange went viral online, and it poured gasoline on the fire. From the White House to Harvard's own Jewish Center, condemnation rained down. Harvard students and alumni were aghast that their university's president seemed unable to plainly say calling for genocide is against the rules. The very next day, Dr. Gay issued a public clarification, finally declaring, "Let me be clear, calls for violence or genocide against the Jewish community are vile, they have no place at Harvard, and those who threaten our Jewish students will be held to account." But by then, the damage was done. Congress announced an official investigation into anti-Semitism at Harvard, and a prominent rabbi resigned from a Harvard advisory board in protest of Gay's testimony. This is the context in which President Trump stepped in. The nation was watching elite universities struggle and often failed to respond decisively to anti-Semitism within their walls. From Trump's perspective, and that of many conservatives, these universities brought it on themselves. They enforced so-called woke codes of conduct for every other bias under the sun, yet seemed paralyzed or apathetic when Jewish students were the ones under attack. But can he actually do that? Is this just bluster, or could Harvard really find itself losing its tax-exempt status, a benefit it's enjoyed for well over a century? To answer that, we need to turn to important Supreme Court precedent. Hit like, subscribe, and let's unpack how Trump might actually win this fight. Here's the key principle. Tax-exempt status is a privilege, not a right, and it comes with certain strings attached. Under Section 501c3 of the Internal Revenue Code, nonprofits, including universities, must serve charitable or educational purposes in the public interest. If an organization's conduct runs counter to established public policy, the IRS can deny or revoke its tax exemption. This isn't theory. It's happened before, at least once in U.S. history, and that one time is precisely what Trump's team is pointing to now. The precedent is the landmark case Bob Jones University versus United States from 1983. If you missed it, I went over this case in an earlier video, and we'll drop a link down below. Bob Jones University was a private religious university in South Carolina that, in the 1970s, had racially discriminatory policies. Notably, it had a ban on interracial dating and marriages among its students. This was an openly segregationist stance, rooted in the school's interpretation of biblical teachings. To the federal government, this was unacceptable. In 1970, the IRS announced that schools practicing racial discrimination could no longer be treated as tax-exempt charities. Bob Jones University fought back in court, claiming religious freedom and arguing the IRS had no authority to do this. The battle lasted well over a decade, but in 1983, the Supreme Court ruled against Bob Jones University by an 8-1 margin. The court held that the IRS did have the power to deny tax benefits to organizations contravening fundamental national policy. Chief Justice Berger's opinion made it clear that eradicating racial discrimination in education is a fundamental national public policy backed by every pronouncement of the courts, Congress, and the executive. Since Bob Jones University's racist rules flagrantly violated that public policy, the IRS was justified in revoking its tax-exempt status. That Bob Jones case is the legal linchpin of Trump's threat to Harvard. If racial discrimination was enough to cost a university its nonprofit status, could anti-Semitism, harassment, or discrimination against Jews be treated similarly? Trump's argument is yes. In fact, his administration has explicitly nodded to Bob Jones. By invoking the public interest standard in his Truth Social post, Trump was alluding to the very language of that case. The logic? Fighting anti-Semitism is as much a fundamental national policy in 2025 as fighting racism was in 1983. Is there evidence that anti-Jewish discrimination is indeed against public policy? Absolutely. Federal law, Title VI of the Civil Rights Act, already prohibits discrimination on the basis of race, color, national origin at educational institutions that receive federal funds. And the government has interpreted this to cover anti-Semitic harassment as well. President Trump himself, back in 2019, signed an executive order reinforcing that Title VI should be used to protect Jewish students from anti-Semitism on campus. So there's a strong policy basis to say universities must act against anti-Semitism, just as they must against racism. Legally, revoking Harvard's tax exemption would not be instantaneous or simple. The IRS can't just flip a switch at Trump's request. In fact, federal law forbids the president from directly ordering an IRS audit or action against a specific entity. However, the administration can certainly put Harvard under a microscope and recommend action. If the IRS decided to proceed, Harvard would be entitled to due process, notice of the proposed revocation, an internal IRS appeal process, and then the ability to fight it in court before anything final happens. So yes, Trump does have a case he can make. The Bob Jones decision shows a path. If you can frame the university's behavior as contrary to a fundamental public policy, then legally the IRS can revoke tax-exempt status. The president would claim he's not punishing speech at Harvard, he's punishing discriminatory conduct, the failure to provide Jewish students a safe environment. And unlike ordinary viewpoint disagreements, discrimination and harassment have never been protected rights of a university. In fact, Trump supporters argue he's upholding the spirit of civil rights laws, enforcing them more boldly than ever before. However, and this is a big however, there's another side to the coin. If this starts to look like the government punishing a private institution for the views expressed on its campus, the First Amendment alarms start to go off. Let's examine how Trump might lose this case. The Supreme Court has been crystal clear that the government cannot deny benefits or impose sanctions solely because of a speaker's viewpoint. In a famous 1958 case, Spicer v. Randall, the court struck down a law that denied a tax exemption to people who advocated, quote, un-American ideas. In that case, advocacy of overthrowing the government. Justice Brennan wrote that such a discriminatory denial of a tax benefit is in effect to penalize them for their speech, and the same as if the state were to fine them for it. In other words, using taxes or tax-exempt status to punish speech is forbidden. However odious one finds pro-Hamas slogans or other extreme statements on campus, the government cannot simply decide to pull a university's tax benefits because it dislikes the viewpoints being expressed. So, if President Trump's move were seen as pure retaliation for Harvard harboring anti-Israeli sentiments or left-wing ideology, it would almost certainly be struck down in court as unconstitutional. The First Amendment protects even offensive, hateful speech from government reprisal. Trump's team is aware of this, which is why they couch their actions, not as viewpoint-based, but as enforcing anti-discrimination laws. The trick is drawing a line between the speech and the conduct in these campus incidents. Where does free expression end and unlawful harassment begin? This can be an admittedly gray area. Universities themselves struggle with it. What Trump is likely to argue is that Harvard's failure was not suppressing speech, but failing to maintain a safe, non-discriminatory environment. If Jewish students have been blocked from campus spaces, if their dorms have been vandalized with anti-Semitic graffiti, if they're being physically intimidated, those are actions or threats that go beyond protected speech. Indeed, reports have emerged of exactly such incidents. Students shouting down and blocking Jewish students' access to buildings, masked agitators terrorizing campus areas with intimidation, even assaults. The ADL cataloged many examples. Jewish students being slandered as Zionists, barred entry to events, facing violence under the guise of decolonization. These, the ADL correctly notes, are cowardly acts of bigotry, not legitimate discourse. And if a university failed to address these offenses, let alone punish the perpetrators, then it's breaching its legal duty. In short, Trump has to walk a tightrope. He can use Bob Jones' rationale to say, we won't subsidize Harvard if it institutionally tolerates anti-Semitic discrimination. But he cannot lawfully say, we'll punish Harvard unless it silences voices I disagree with. The former is about upholding public policy. The latter is viewpoint censorship. The reality may lie somewhere in between, and that's what makes this a potential court battle for the ages. What started as student chants and ill-conceived letters at Harvard has escalated into a national test of how far a president can go to hold universities accountable. President Trump's threat to revoke Harvard's tax-exempt status is more than posturing. It's a direct challenge to the culture of academia and a bold assertion of executive power. It says, if you won't police hate on campus, we will. Many Americans, fed up with campus double standards, find that message resonant and even overdue. On the other hand, the specter of a government punishing a university, even an elite liberal one, for what happens on its campus sends chills down the spines of civil libertarians. Universities are places of debate, protest, and sometimes extreme ideas. Today, the issue is anti-Semitism, and the target's Harvard. Tomorrow, it could be another issue in a different university. The precedent set here matters. If Harvard's nonprofit status can be yanked for failing to quash anti-Semitism, one could ask, what about a university that fails to quash anti-Muslim bigotry? Or on the flip side, could a future left-leaning administration try to pull the tax-exempt status of a religious college that espouses views contrary to LGBTQ rights? These scenarios show that the power to punish via tax status is a potent and double-edged sword. Personally, it's clear Harvard and other schools did fail in their moral responsibility at times. When Jewish students were fearful, these institutions responded with equivocation about genocide, where moral clarity was needed. That failure gave an opening for government intervention. In the end, the principle that emerges should be a balanced one. Universities must not become safe havens for hate or discrimination. That is not what tax-exempt status or federal funds are meant to support. Public policy and basic justice demands that Jewish students and all students be protected from true harassment and intimidation. At the same time, our Constitution demands that we combat anti-Semitism without shredding free speech. As citizens and viewers, we should watch this space closely. This is about more than Harvard. It's about the kind of society we want, one that's unyielding against hate, yet unwavering in freedom. Striking that balance is pretty hard, but it's what the Constitution and our conscience calls for. President Trump's crusade against Harvard will test that balance like never before. Stay tuned. I'll keep you updated on how the legal footing develops. Let's hope that in the process of winning the fight against anti-Semitism, we don't lose sight of the freedoms that make that fight worth waging. I'm Benjamin Barr, and I'm thankful you joined me today. Each week we examine one current constitutional issue bubbling up in an evergreen topic of constitutional law. Be sure to like and subscribe and join us next time where we examine yet another constitutional controversy.